learned last week that everyone seems to like visuals. And I actually spent hours last night working on a tri-board that our kids used in school and drew out this timeline and took it up. And I was so proud of myself and showed it to my husband. He looked at me and was like, "You have got to be kidding. You are not using that." So he and I worked for another couple hours, and he turned my tri-board into this presentation, which I've given to you, which you can use to hand out if you find somebody that might need the information, or keep for yourself. It's bankruptcy timeline, because to me, unless you're in an urgent situation and you're dealing with an immediate need, such as a foreclosure, it's always important to look at the entire picture. You would be surprised. The entire picture, and plan a bankruptcy filing. It is not uncommon, just so you know, for people to come in on the day before a foreclosure and say, "I need to file bankruptcy to stop this foreclosure." And this is something, believe me, they have had notice about for at least a month. But everybody always thinks they can fix it. I deal primarily with Chapter 7s, which are traditionally liquidations, and Chapter 11s, which are reorganizations. And they each have different timelines, as do the parties involved. There's generally, in every bankruptcy, you're going to have your debtor, the person that filed, you're going to have your creditor, the person that's owed the money, and then you have a trustee, whether it's a Chapter 7 trustee, who's in charge of liquidating assets, or a Chapter 11 trustee, who's in charge of making sure that the debtor follows the law, maintains the required deadlines, and that the creditors are heard. So the third page that you have is filing date, debtor timelines. These are things that I have to look at when I'm representing a debtor. The first thing is a means test. I need to look for the past 6 months before they file at their income, because there are income requirements. If you make too much money, you cannot file for bankruptcy. Now, you do get to credit against your income things such as mortgages, car payments, but it's like a 5-page questionnaire calculation that goes into determining whether someone even qualifies. If you decide somebody qualifies, then you have to look at, have they made any transfers to insiders within the year? As I said before, I'll have clients that come in and say, I need to file for bankruptcy, but don't worry, I have transferred my house into my spouse's name. That's a problem. That's fraud. We can't do anything with that. And if there's been a transfer, a lump sum payment to a relative who loaned the money while they're struggling along, if you can hold that client off for a year, you will protect the client's discharge, and you will also protect the relative who received the money. Because otherwise, if you file, the debtor risks not getting a discharge, and the family member risks being sued by the trustee, and that's the trustee's job. I also, when I'm timing a Chapter 7, I look at the debtor's bank account. You do not want to file the day after a debtor gets paid, because then they have a lot of money in their bank account. I usually look and see when have you paid all of your debts? When are all your debts paid and your bank account is at the lowest, his or her bank account is at the lowest amount of the month. That's when you want to file for bankruptcy, because you have to list all of your assets, and there are limited exemptions to protect those assets. In Chapter 11, one of the items you have to look at when you're filing is, have you paid all of your employees? Because if the employees of the business have not been paid, it takes more time and it costs the client more money for you to go into court, for me to go into court and ask the court for permission to pay these employees to keep them going. In a Chapter 7, we have reaffirmation agreements. People come in, they have car loans. Most people do not really own paid-off cars. If they want to keep their car, they have to reaffirm that debt. Oh my gosh, I'm never going to make it through something. So, you know, that's something that has to be done within 30 to 60 days of the filing. And fraudulent transfers, no matter when they're done, are not good. The bankruptcy petition, requires disclosure of transfers that are made within 4 years of the filing. And if the trustee gets wind from a creditor that a transfer was made even 8 years later that could be fraudulent, the trustee, under Georgia state law, can go back and undo that transfer. There are a lot of strong-arm powers that the trustees have. The filing date of a bankruptcy is a snapshot, and the timeline runs from before it to after it. Going back on the timeline from the filing date, we look at activities of the debtor. Transfers that were made, loans that were taken out, credit card usage, and going forward, we look at things that they have to do, obligations such as making payments to secured creditors, filing plans of reorganization. One thing I've spoken about before and then I'll include for you is preferential transfers. Any unusual payments that are made within 90 days of filing bankruptcy are presumed to be preferential. And it is on the creditor to prove that it's not. All it has to do is have been made. So I hope you'll look at the packet that I've given you. If you have any questions, please feel free to call me. If you have a client you think that I could help with any of this, connect us in a three-way or let's have lunch together. Gai Lynn, bankruptcy attorney.